everybody, I'm Jesse Weber, and welcome back to Law and Crime Now. We have a big show today. We're going to be focusing on the latest developments in the Vallow Daybell case, as well as the Robert Durst trial. Let's start with Lori Vallow. Now, again, this is that Idaho mother who's been charged in connection with the disappearance of her two children, 7-year-old Joshua J.J. Vallow and 17-year-old Tylee Ryan, both missing since September. She's been charged with everything from child abandonment to ultimately solicitation and contempt. Now, Friday was an interesting day here on the network. We covered her bail reduction hearing. Now, their defense attorney, Mark Means, filed a motion to have her bond reduced from $1 million. And he cited everything from, hey, given COVID-19, it's really hard to make that unreasonable sum. Also, it should be noted that he said he believes his conversations with his client while she's in jail are being secretly recorded and disseminated. That's a big accusation here. He says she needs to get out of jail so he can have a privacy and private conversations with his client. Well, if you haven't seen it, this is what the judge had to say about that motion to reduce the bond. Take a look.
I would certainly invite evidence that conversations are being inappropriately recorded between counsel and client of any sort, whether it's Ms. Daybell or anyone else, to be brought to the court's attention. I'm not sure a motion to reduce bond is exactly the way to do that, but certainly we don't want that happening, and I'm confident that the jail will make sure that that doesn't happen. I happen to believe that Mr. Wood and Madison County Sheriff's Office have great motivation to make sure they don't do that in this case or any other, because it is a serious violation of constitutional rights. And if it actually has occurred, as Mr. Means speculates that it might, and I guess what I should say when I say that if it's actually occurring, what I mean is if conversations between an attorney and client without a warning that they're being recorded are actually being recorded, then that would certainly be something that I would want to know about. But I don't really have any evidence that that is actually what is going on here. So on that basis, I'm denying the motion for bond reduction because I cannot find any good cause to reduce bond further than it already has. And I would invite Mr. Means to consult with local defense attorneys who I'm sure have come up with alternatives during this time, and then also have a long track record of dealing with Madison County Jail. I'm aware that different jails can have very different procedures, and I'm confident that there are a number of defense counsel in Madison County that would be willing to talk to Mr. Means about ways to surmount any virus problems at the jail in regards to communicating with clients.
Okay, so as you heard, that bond reduction not happening. She is still in jail on $1 million. Let's bring in my guests right now. A familiar faces. We got Law and Crime fellow host Terri Austin, as well as executive trial producer Cathy Russon. It's great to have you both here. Terri, why did the judge make this decision, and do you agree with it?
I do agree with it, Jesse. She made this decision because she could not find good cause. She said that they can do something else other than reducing the bail here. They can make sure that they talk to local counsel. Local counsel can tell them ways to have conversations with the client without risking letting the defendant out on bail. So I think she made the right decision. She is a flight risk, if you ask me. And the fact that she did not produce her children when she was ordered to, she should stay in jail, and she and her attorney should figure out another way to communicate.
Terry, but the thing is if you listen in the news, there are other high-profile defendants who are kind of getting some relief because of COVID-19. And here, the idea that $1 million is a pretty high bond. She's not charged with murder here. Do you think that's, I mean, is that fair given everything that's going on? And on top of the allegation that these private attorney-client privilege conversations are being recorded, the prosecutor, who we're going to get to in a little bit, admitted that some of those conversations were recorded. Now, it's a separate question of should Mark Means, who represents Lori Vallow, should have known that these conversations were being recorded is one thing, but there seems to be a serious issue here that the judge was taking account of.
Well, I do believe that all defendants have a Sixth Amendment right to representation. They have a right to privacy. But I understand, as far as I'm concerned, there's 6 people who are either missing or dead. Yes, she's only been charged with abandonment and not paying child support at this point. But when you think about the reality of this situation, I think the judge is taking all of that into account. She has not said where her 2 children are. And if she knows, she should certainly say this. So I think she should be in jail for now.
Let's go back to Mark Means, okay? Because he was a central focus on Friday. This is Lori Vallow's attorney making that argument that I just described. Take a look.
When they brought my client in, we sit down and we start having the conversation. I can't recall on that day if I heard the recording statement or not, but I was told repeatedly, asked repeatedly to the deputy, was assured that it wasn't going to be recorded. We had our meeting. I left. I go do some visits. I come back to visit with my client. Same thing. I want to make sure that this is not recorded. No, Mr. Means, it is confidential. It is not going to be recorded. The recording services is turned off.
And was that on March 30th and March 31st that you're referring to?
That was over from March 30th, and I believe I was here until April 2nd. And so I relied upon that representation to have that communication. My gut was, I think they recorded it. I heard beeping on the phone that just, I don't know if it was a cheap landline. I don't know if it bumped my ear, because as I sit there with the ear pinned to my shoulder, typing on a laptop, trying to show documents to my client, it's extremely difficult. So I go back and I file the amended motion before the court, bringing up my belief that I think it was recorded, even though I was told repeatedly on each time I was there that it would not be recorded. So I file that motion. Now, fast forward, the prosecution does not file a response. They do not call me after I file that motion. They do not make contact with me and say, yes, Mr. Means, we accidentally recorded it, but we've deleted it. We've done what we needed to do, or whatever it is that they were going to do as far as handling it. They file a response on the 13th, give or take 2 hours before our informal conference, and they admit in a statement as an agent of the court in their paragraph, and I believe it was paragraph.
I'm looking at the first objection to your amended motion of April 7th. Is that, are you for, you said April 13th, so I'm trying to.
Yes, Your Honor, I'm sorry, it's April 7th. And in that, paragraph 5. The state represents in paragraph 5 to the court that the attorney, that they learned, and this is where it gets unique and these affidavits come into play, that one conversation between the defendant was accidentally recorded. Okay? They admit it. This is a filing by an agent to the court on that day, on the 7th, before that hearing. Now,
okay, so I want to go to you, Cathy, because you watched this with me, but you were also following our trial watchers, our chat rooms. What's the general perception of Mark Means, Lori Vallow's attorney?
They're not impressed with him at all. We looked up his practice, and he doesn't have criminal law under or defense. He's not a criminal defense attorney. He's a family law attorney and personal injury and bankruptcy attorney. I don't know what the connection is. I don't know why, because he is now representing Chad Daybell, who hasn't been charged with anything, and Lori. They're using one attorney, and it's him, who does not specialize in criminal law. And I'll tell you, he got slammed on social media and in our chat rooms during the hearing. He rambled on for a long time.
Yeah,
He
and I don't
said,
think he could be too surprised at that, considering he said in open court, look, I'm not a seasoned attorney. We're going to talk more about Mark Means, and when we come back, the Dateline special on this whole case. Stay tuned. Welcome back to Law&Crime Now, everybody. We're focusing on Lori Vallow Daybell, the mother charged in connection with the disappearance of her 2 children, and more specifically how on Friday her motion for a reduction in bond was denied by the judge. Right now, let's go to the prosecutor, Rob Wood, who responded to the defense's accusations that his secret conversations with his client were being recorded. Take a look.
On the 31st, they do have these recorded phone calls. Again, which I guess I don't quite understand what defense is arguing, because he said he had a hunch, but in paragraph 5 he makes it clear he knew a call was being recorded. Not only that, every recorded phone call on Telmate starts with that warning. These calls are subject to monitoring and recording. And so the problem is they're now saying this is good cause for a bail reduction. I don't think that's the case at all. I think this is an attempt to divert the court and the public from the actual facts of the case, to deal with the actual case. It's a way to try and get the client out on an issue that doesn't exist. And here's the thing. When an attorney and the defendant hear this call is subject to monitoring and recording, it's no longer privileged. They can't claim privilege. Case law is clear on that. They know that a third party could be listening. And the problem the state has with this document is that it's clear that on the 30th, and the records support this, that phone call was not recorded when they'd asked for it not to be.
And what you just heard basically was what the judge agreed with, the fact that this motion made by the defense wasn't enough. Terri, I want to go to you. Where are we going next in the Lori Vallow Daybell case? I know her preliminary hearing is in July. What can we expect between now and then?
I think one of the things the court is going to have to do is to set the schedule for what's coming next, what kind of motions, what is going to get into the trial, what is not going to get into the trial in terms of evidence. And, you know, the charges, as you mentioned earlier, are abandonment and the fact that she's not paying child support. So what specific evidence will they be able to present once the trial does begin? If in fact it does begin, Jesse, because we know with COVID-19, there have been so many delays and it could very well be delayed again.
Well, look, I got to tell you, between now and then, there's multiple investigations going on and trying to understand all the characters in this case. Dateline did a special last week on the Lori Vallow Daybell case, and we're going to play some clips right now. The first part is discussing the marriage between Lori Vallow and her current husband, Chad Daybell. Take a look.
Consider what the police found when they saw what was on Lori's computer. Eventually, we were able to see it too.
Somebody went on Charles Vallow's Amazon account and purchased some wedding rings. We know
Wedding rings?
Wedding rings, bands, not diamond rings, nothing flashy, but unique looking bands.
Sterling silver, southwestern malachite gemstone bands, to be precise.
We know this because we've been provided a screenshot clearly showing that they were in the Amazon cart, that the sale had been finalized, and that they were being shipped to Charles Vallow in Rexburg, Idaho. Charles Vallow was dead at that point, but Lori Vallow was living in Rexburg, but had not yet married Chad Daybell.
In fact, Chad Daybell still had a wife.
Still had a wife, and we don't think much about the rings until these wedding photos surface of Chad and Lori on the beach.
And lo and behold. So here's a picture of, this is the actual, it's a close-up of their hands at the wedding. And you can see the wedding rings. Are those the wedding rings they bought on Amazon?
Those are the ones that were bought and sent to Rexburg, Idaho.
How long before Tammy died?
17 days before she died.
All right, Kathy, you know I'm coming to you. What should we be making of this?
Well, let's see. Purchased rings, have them sent to Lori's apartment in Rexburg, Idaho, 17 days before Chad Daybell's wife dies. They were planning on getting married 17 days before his wife died. That tells the cops something, right? I don't think they were planning on getting a divorce that quickly, and they were going to hang on to the rings for months while the divorce was finalized.
And look, we know that Tammy Daybell, the circumstances surrounding her death are under question. Her body was exhumed, an autopsy conducted. We still don't know the results of that. Let's go more to this family tree. I want to turn to Lori Vallow Daybell's niece, who is also a subject of this Dateline special. Take a look.
And into that small circle around Lori, a new face would soon appear. Melanie, still in Idaho, went on the LDS dating app Mutual and met a man named Ian Pawlowski.
It's hard to put into words what I felt, but as soon as I saw her, I knew. She sat down, and there was so much that we had in common.
And 2 weeks after they left the restaurant that November night, Ian and Melanie got married in Las Vegas. And what do you know? That very same weekend, also in Vegas, Lori's brother Alex got married to a woman named Zulema. We knew we'd heard that name before. And sure enough,
Lori talked about her a lot. She said that Zulema had the power to control the elements, and just really bizarre things that was almost laughable.
let's recap for a moment. After Lori's brother Alex killed her husband Charles, and Lori moved in secret to Idaho, in just a few weeks during the fall of 2019, Lori's children vanished. Chad's wife died suddenly. Chad and Lori got married. Someone took a shot at Brandon, the soon-to-be ex-husband of Lori's niece Melanie. Melanie met and married Ian. Lori's brother Alex married Zulema. Anyone would be inclined to think that something very unusual was happening inside Chad and Lori's circle. Anyone, it seemed, except the members of that circle themselves.
We're all kind of doing our own thing. There's no cult, there's no planned marriages and all this that we've been accused of.
Kathy, back to you. What do we know about the niece? What do we know about her role and statements in all of this?
It's very interesting. So what we know about most of the members of this, whatever, religion, come from the Mormon faith, the Church of Jesus Christ of Latter-day Saints. But they've added on to those doctrines, believing that Chad Daybell receives additional revelation from God to himself. And so the guy that marries Melanie, the niece, that Ian, appears to get himself into something he didn't really know he was getting himself into. And he's the one that gives police a lot more information about the beliefs of this cult. So I don't know. I think Melanie probably believes what she's saying. She probably believes she's not a member of any kind of cult and there's nothing nefarious going on.
Terri, I want to go to you. Unlike how Mark Means describes himself, he doesn't say he's a seasoned attorney. You are a seasoned attorney in this space. And my question to you is, can we expect future indictments? Can we expect other arrests? I mean, there's this orbit of different people and 4 mysterious deaths connected to Chad Daybell and Lori Vallow Daybell. Do you expect things to really heat up with more indictments or perhaps new arrests?
I do, Jesse, because to your point, there are actually 6 people. Obviously, the 2 missing children. Lori has 2 ex-husbands who've passed away. The fact that the wife of her current husband died and her brother, that's just too many deaths in a very short amount of time. I absolutely believe the police and investigators are looking at all of the evidence, and ultimately, I think they will bring additional charges against at least Lori, and we might see charges against others as well. But I think she better prepare for the fact that she's going to have charges beyond abandonment and beyond the fact that she hasn't paid child support.
Kathy, I want to ask you, I think we have about 30 seconds. What about a witness list? We're hearing about all these people. Who could we expect to testify at Lori Vallow Daybell's trial?
Well, the grandparents of JJ, they're the ones that initially alerted police to a welfare check. They had always been in constant contact with him, so they could testify. The school where JJ was enrolled, anyone that surrounding that knew these children and had contact with both of them, and then all of a sudden no longer had contact.
Well, I tell you, we're still learning more about the different relationships and different characters, and when that trial ultimately happens, if that trial ultimately happens, it'll be something to follow. We're going to continue to provide you updates on the Lori Vallow Daybell case, but when we come back, we're going to switch gears because we have a new update for you in the Robert Durst trial. His defense attorneys are asking for a mistrial. So stay tuned here on Law and Crime Now. We'll be back after this.
Do you have any objections to us looking at everything on the phone?
In a way, she's almost a younger, more vibrant version of Shanann.
As soon as he met Nicole Kessinger, Chris wanted out.
She knew that he would always choose her.
That tells you everything you need to know about Chris Watts, that he didn't know what it felt like to love someone. Chris's solution was to plot murder.
She had proof something else was going on.
Welcome back to Law and Crime Now, everybody. We're focusing right now on the Robert Durst trial. Remember, he's on trial for the murder of his best friend, Susan Berman, who was gunned down in 2000. The state has said that he killed her in order to keep her quiet about what she knew about his alleged role in the disappearance of his wife, Kathleen, who's been missing since 1982. The defense said he didn't kill Susan. He didn't kill anybody. He walked into the house, saw her body, panicked, and ran away. Now, this was a trial that began in March, but it was suspended because of the pandemic. Now his defense attorneys are asking for a mistrial. Before we get into that, though, let's do a recap of the case by going back to the state in their opening statement from this trial. Take a look.
So as you are all aware, this case involves what the people are going to present as 3 different homicide cases, and in fact, 3 different murders. The killing of Cathy Durst, the killing of Susan Berman, and the killing of Morris Black. So, I'm not going to start at the beginning. I'm going to start at the beginning of the case that you are here to decide, which is the murder of Susan Berman. December 24th, 2000, a little after 12 noon, the following 911 call was received by the Los Angeles Police Department, by their dispatch center.
LAPD operator 348. Yes, hi. I was in Benedict Canyon, and my next door neighbor, one of our other neighbors, found her dog on the street yesterday. And was it dead? No, we have her. The problem is, they gave us the dog, and we went over next door to see if Susan was home, and her car's in the driveway. She's not answering her door. There are packages on our doorstep. She's not answering her phone. Her back door is wide open. So I don't know what's going on. The door, it's open door. Y'all did not go inside. Oh, no, we're not. Okay. No, we're not. We have, her other dogs are in her yard, and they're barking their little heads off, and, she would not, I mean, our area, there are a lot of animals. Nobody leaves their dog out overnight, so it's very weird. Okay, what's her address? Actually, it's a good question. I can give you mine. She's next door. I'm not sure her number. Yeah, what's your address? 1531 Benedict Canyon Drive. She lives by herself, and I hate to think. Yeah. Is she elderly or? Not particularly, but you never know. I mean, teenagers hit their head in the shower and get knocked out. Yeah. And what was your name? My name is Catherine Cutter, Cuttpr. Okay, let's go ahead and get talked about there to check it out. Thank you very much. Your house and make your direct, okay? Okay, thanks. Bye.
At the time that she was killed, Cathy was a 4th-year medical student. She's almost a doctor. She's going to graduate in a matter of months. And the evidence is going to show that Cathy's a strong woman. she's nobody's doormat. But the evidence is also going to show that, like a lot of strong women, she was a victim of someone who was abusing her. And she made the decision to remain in the relationship. And the evidence is going to show that that decision is going to cost her her life. January 6, 1982, the evidence will show this is now 24 days before Bob Durst is going to kill her.
Okay, we know where we were. Let's see where we're going. I want to bring on my guests right now. Investigative journalist Pat LaLama is with us. Also with us is Law&Crime own Linda Kenney Baden, as well as executive trial producer Cathy Russon's back with us. Okay, it's great to have you all here. Pat, I want to start with you. The defense has moved for a mistrial. What do we know about this? And my understanding is you've had a conversation with the defense. Walk us through it.
I spoke with lead defense counsel Dick DeGuerin over the weekend, and he put it plain and simple. It's been a long time since these jurors have heard the evidence that was presented to them in those opening statements and a couple of days of testimony. He says it's unfair to expect them to come back and pick up where they left off. He also says that the coronavirus has changed the jurors. Think of it this way. None of us are really the same people we were before it happened. So now a lot of these jurors who are so dedicated to the process, maybe they have new financial issues, maybe they have childcare responsibilities, maybe they've been sick or worse. So you can't expect everyone to come back and pick up where they left off.
Linda, it's a pretty novel argument. We've never seen anything like this before. What's the chances that the judge actually grants a mistrial here?
Well, you know, he's got to go through procedures first, Jesse. I think what he's going to do, though, is say, okay, let us look at all the jurors. Let's question them. Let's see how many can come back. We have 11 alternates, remember, here. Maybe we'll just put all the alternates in. There's going to be a lot of questioning before the judge is going to immediately grant a mistrial. But really, Jesse, Pat is right. We aren't the same people. The jurors aren't the same people. We don't know whether or not any of them can stay for a 3, 4, 5 month trial after they haven't had any work for 2, 3, 4, and maybe 5 months by the time it's ends.
Cathy, you were there. I mean, you saw jury selection, right? I mean, to get another jury, if this is ultimately a mistrial, what are we looking at here?
With Linda that I believe this judge wants to continue this trial. He does, keep it going. He does not want to delay it any further. And I believe that he will question all the jurors and try his best to get this back on track. He's already annoyed with all the delays, and I think he will do that. However, I think the defense has a great argument. There's no way, not just the timing between the last evidence they heard and when they finally get back to trial, but everything that's gone on in their lives since then. There's no way they remember what happened in those first few days of trial.
Right. Well, we talked so much about the defense. Let's go back to when we heard the defense in their opening statements from the beginning of this trial in March. Take a look.
He doesn't know who did. He did find her body shortly after someone had shot her in the back of the head. He was coming to visit her for the Christmas holidays, which they had done before. What you're looking at now is a letter that was among Susie Berman's possessions after she died. It was an earlier letter that Bob wrote to Susie. They were very, very close friends. And it talks about how he was unhappy during Thanksgiving and Christmas with his family, who he was still talking to at that time. Remember, this is sometime in the late 90s. And so he said, but this is what I want to do this year for Christmas. I want to get us 2 rooms at La Costa whatever spa you or resort you would like to go to for a couple of days before Christmas to a couple after, 4 days, maybe a week, and I'll meet you there. Understand, this is not a letter that was written right before Susan was murdered. This is several years before. We don't know exactly. It's not dated. But it set up a pattern, a habit, for them to spend the Christmas holidays together. I'm not an artist, as you can probably tell, but in my simple way, what I've drawn on the board is 3 buckets. This bucket represents what I think the evidence will be about the Susan Berman murder. This bucket represents what I think the evidence will be about Cathy Durst's disappearance. And I've drawn them empty. The Morris Black bucket is full. And it's full of bad stuff, bad evidence. And our concern is that the evidence about Morris Black will spill over into those other buckets. And that the evidence will show that those buckets, those other buckets, don't have evidence in them.
Standing objection.
Straight argument, Your Honor.
Okay, you both can do it.
We're just trying to take out the defense, Your Honor.
Don't do that.
That was the defense trying to say to the jury, here's what you should consider, here's what you should not consider. Pat, I want to go back to you. This motion for a mistrial, my understanding is one of the other arguments the defense said is, look, our client is 77 years old. He's not in great health. To put him back on trial in the middle of the coronavirus pandemic puts him in extreme danger. What do we know about his current condition and that argument?
Dick DeGuerin told me that he's in less than good shape. We know he's had a history of health problems, but Dick told me that just in the last few weeks he's been hospitalized twice and that he's being held in the medical unit of the jail. They do take his temperature at least 3 times a day, but Dick could not say whether they have tested him for the coronavirus. He didn't think that they had, which I find a little strange. You'd think he'd be the perfect candidate, but they do watch him. He's not well. And think of this also. I mean, Dick was reminding me that all of the members of the defense team are in that age group where, you know, they've got to consider their own health in traveling back and forth. You know, one of the things I was thinking about the other day is if the judge did decide we need to move forward, and I think Kathy's right, he does not want another delay. What about this? What if they just repeated the first six days so the jury would be reminded of what they listened to for 6 days? I don't know, maybe that's a pipe dream, but is that even a possibility?
Linda, great question. We have it a lot on audio recording. Some of it's been videotaped. Can they rewatch it? Is that even legal?
Bob Durst has a right to be there. The attorneys have a right to prep for trial. The attorneys have a right to be in trial. The attorneys have a right to talk to their client. Do you really think that anyone who's a witness wants to get on a plane from New York, where you may not be able to right now, to go to California, if you're in that age group or have, let's say, diabetes, or even if you're overweight? I mean, do you disclose that? I mean, you know, we have a whole myriad of issues here that the California Supreme Court has to address, and it's not going to be addressed just by Judge Wyndham repeating testimony. I don't think, Pat.
Well, there's a lot to break down here. Clearly more with everything that's happening. Let's take a break. When we come back, more to dissect.
Do you have any objections to us looking at everything on the phone?
In a way, she's almost a younger, more vibrant version of Shanann.
As soon as he met Nicole Kessinger, Chris wanted out.
She knew that he would always choose her.
That tells you everything you need to know about Chris Watts, is that he didn't know what it felt like to love someone. Chris's solution was to plot murder.
She had proof something else was going on.
Welcome back, everybody. We're focusing on the Robert Durst case, the man on trial for the murder of Susan Berman back in 2000. And we're really focusing on the fact that the defense just made a motion for a mistrial due to the COVID-19 pandemic, saying you really expect a jury to come back and just pick up where they left off 2.5, 3 months later? Not quite. We're going to get more into that argument in a minute, but I want to go to some of the witnesses that we've heard and some of the things that we've heard. Let's go right now to Thomas Durst, who was Robert Durst's brother. He testified for the prosecution. Take a look.
First of all, how do you feel about being here today?
I hate it.
Okay, and can you tell me why you're here?
I was subpoenaed.
And did you come voluntarily?
No, sir.
And did you do everything in your power to try and avoid coming here?
Times 10.
And can you tell me why is it that you don't want to be here today?
I object to that. That's not relevant.
Grounds, Your Honor?
Overruled. You may answer the question.
Oh, I'm sorry, sir. I'm humiliated to be here. This is a horrible experience, and I'm fearful of my brother.
As far as you were aware, given that you were a member of this family and had an interest in the trust, etc., was there a plan that you were aware of originally as to who was to replace Seymour?
Yes.
And who was that to be?
Robert.
And Robert or Bob, you're speaking of your brother, correct?
Correct.
And he was the oldest child in your family, is that right?
That's correct.
Now, growing up with your brother, can you describe how he was with money? If I were to ask you, was he generous with his money?
I never knew him to be generous.
And if I were to ask you, based on your experience with him, if I were to have you rate on a scale of 0 to 100, with 0 being the cheapest person you know, and 100 being the most generous, where would you rate your brother?
In comparison such as that.
That's not an objection under California law.
Relevance is
Your Honor, I can make an offer of proof.
yes.
The offer of proof, Your Honor.
I object to an offer of proof in front of the jury. Well, it's relevant.
Let's go back.
Okay, Linda, I want to jump back to you now. So as we're talking about COVID-19 and its implications for the Robert Durst trial, whether there will be a mistrial, let's say it actually does continue. Let's say this trial does continue back. I think June 23rd is the date they've set. The prosecution is asking to have videotaped testimony played for the jury. So instead of having some older witnesses who are older than 65, including what we believe is the state's star witness, Nick Chavin, testify in front of a jury, to have this videotape testimony. What are your thoughts on allowing that to happen?
You know, I don't have a problem with that, Jesse, because that's something tried and true in the law. What you don't want this trial to do is become witnesses or jurors or anyone to become lab rats, right? You don't want any high-profile any murder case where you have victims and you have justice and you have a defendant's rights to be an experimentation. I would say to you, Jesse, you know what Tom Durst just said? You know, I had to be subpoenaed. I didn't want to come. Well, that's going to be what most people are going to feel. I don't want to be another victim of Robert Durst by attending his trial.
Pat, what is expected of the state at this point? Have they responded to the defense saying we want a mistrial? What is their view on all of this? Because COVID-19 is kind of hitting everybody, no matter which side you are.
And from John Lewin, the famous cold case prosecutor who's trying this case, is that he is doggedly determined to figure out a way to continue on. I think he's praying against all odds that this continues. And his motions have set forth requests to allow these prosecution witnesses to testify via videotape. Nick Chavin, as Linda mentioned, as you mentioned, Nick is the one. He's really important. He's the one who claims that Bob Durst said to him, I had no choice. I had to kill her. It was her or me. How significant is that? Doesn't get much more significant. Also, one of the lead detectives, because some of these people are over 65, they may have underlying health conditions. But one quick thing I want to add on what Linda was saying, nobody wants to be the laboratory rat in, due process. But I do think that this virus is going to change the future. I go back far enough when cameras weren't allowed in the courtroom, where all kinds of things didn't occur that occur now. So I do think the whole world's going to change, and I think that's going to include some levels of criminal justice. So we might have to just get ready for it.
You have to wonder if you're the state, though, to have that videotape testimony, it would have been so much more impactful to have someone like Mr. Chavin literally say that in front of a jury as opposed to saying it over tape, but sometimes you can't get the things that you want. Let's go more back. You mentioned the prosecution. Let's go back to the prosecution's opening statement from earlier on in this trial.
Stewart had talked to Durst while Durst was in custody in a Louisiana jail. So remember, this is about 3 months after his arrest. And this is a conversation that Stewart and Bob are having. Now, the subject of the conversation was, where was Durst at the time of Susan's murder?
Yeah, I saw it yesterday, and we went over a whole bunch of stuff. And they wanted to talk about where I was, when and how, and everything in Los Angeles. And I've been putting it off and putting it off. Just because I'm uncertain and uncomfortable trying to take a position, since I keep remembering things differently, sort of. So I've never spoken to him at all about where I was, etc., in Los Angeles.
Right. I know. What? It's like 14 years ago, for God's sake.
So the evidence is going to show that Bob Durst, back in June of 2015, was still deciding where he was going to say he was. Not that he didn't know where he was, but he hadn't taken a position yet. Absolutely, and without reservation, that whoever wrote the cadaver note is in fact the person who murdered Susan Berman.
You're writing a note to the police that only the killer could have written.
First of all, you agree, as you sit here today, you agree that whoever wrote that letter, they killed Susan. Agreed?
See, I don't know that. I mean, maybe there were two people who killed Susan. It doesn't have to be one person. There could be two people. One person could go into the house to shoot Susan, and the other person could be the driver.
Oh, okay, no, let me, this is what I mean. Whether the person was the shooter or the driver, whoever wrote the note was a part of killing her.
Yes.
Do you agree, right?
Yes.
No question, right?
Whoever wrote that note had to be involved in Susan's death.
After many years of adamantly and repeatedly denying that he wrote the cadaver note, saying that only the killer could have written it, on December 24th, 2019, 3 months ago, Durst stipulated that he wrote the cadaver note.
Cathy, let me ask you this. If this really is a mistrial and this trial's thrown out, I wonder what effect that'll have on the prosecution. You were watching this trial with your own eyes. How is the prosecution doing? To get a do-over might not be in their best interest. Do you think they were winning at this point?
I think that the jurors are very tentative, and they paid a lot of attention. So while by day 3 of the prosecution opening, people like me were like, really, we're still doing this? They really didn't lose attention ever. So I think. But look at that right there. He has him on tape saying, Durst says whoever wrote the note was involved in her death. Now Durst says, I wrote the note. I mean, that's really good for the prosecution. I think if they had a do-over, I'm wondering if John Lewin would shorten his opening.
Well, I know it was over the course of several days. That's something that we haven't really seen. Linda, you're talking about having a new trial. No matter what happens, if this starts again back in June or there's even a new trial, to conduct a trial during a pandemic, during everything going on, what is that going to look like? What difficulties do you imagine?
The problem is, Jesse, we don't know. And it's really interesting because you have attorneys and you have jurors and you have court personnel who are in the at-risk category. Does that mean they have to sit out? Does that mean we have a society of discrimination when it comes to trials? We don't know. And I think we're going to find out pretty soon.
Yeah.
But this case may be more focused on, I mean, look, if I'm Cathy Durst's family right now, I still want the answer to where is my beloved, where is Cathy?
Right.
If I'm
And look,
family,
we have to end this short. I'm so sorry. I want to thank all my
Sorry,
guests.
Jesse.
Let you know on Wednesday we're going to have coverage of the SCOTUS rulings. Thank you.